Welcome to our detailed guide on the patent application process in Sri Lanka, focusing on sections 71 through 79 of the Intellectual Property Act. Creating an invention is only the first step. To legally protect it, you must follow a structured patent application process. This video explains the critical steps defined in sections 71 to 79 of the Intellectual Property Act, number 36 of 2003, in a clear and practical way. We will break down these sections to ensure you understand every part of the Sri Lankan patent application journey. Section 71 details the requirements for a patent application, which must be submitted to the Director General. The application must include a request, a detailed description, claims, drawings if necessary, and an abstract. The description must clearly explain the invention so that any skilled person can understand and reproduce it. Claims define the exact legal protections sought. Remember, false information can invalidate your patent. Section 72 is straightforward. The application will not proceed unless the required application fee is paid in full. Under Section 73, you must submit a search report showing prior art or request a local examiner to conduct one. This checks for existing, similar inventions that could lead to refusal. Section 74 mandates the unity of invention. Each application must relate to one invention or a group of inventions forming a single, unified concept. You cannot combine unrelated inventions. Section 75 provides flexibility. You can amend your application within its original scope or divide it into multiple applications if your invention has several distinct features. Section 76, right of priority, allows you to claim priority from an earlier application filed in a foreign country. This earlier filing date strengthens your position in Sri Lanka. Section 77 establishes the filing date as the determinant of priority over other applicants. Ensure all missing information is corrected within deadlines to avoid rejection. The Director General examines the application under Section 78 to ensure all legal requirements are satisfied. Any errors, such as unclear claims, must be corrected promptly. Finally, Section 79 addresses the grant of patent. If all requirements are met, the patent is granted, recorded, and published. The grant is the culmination of the process, marking your successful compliance with the IP Act. Once granted, you gain exclusive rights to your invention. A patent is generally not refused unless its use affects public order, morality, or safety. Let's quickly summarize the key sections we covered today. Section 71, submit full application. Section 72, pay the fee. Section 73, provide search report. Section 74, one invention per application. Section 75, amend or divide if needed. Section 76, claim priority. Section 77, filing date matters. Section 78, application examined. Section 79, patent granted if compliant. Understanding these steps helps protect your invention and avoid legal issues. Follow for more simple legal explanation.